Hello, Bhaji sir. How are you doing? This is Achal.
Fine, ma'am. Fine, ma'am. All good. All good.
I think we can begin our session. Before we begin our session, Shiladitya, Varun, because you guys are here, and any any issues on assignment submissions or anything? You going okay? And anything you want?
Well, ma'am, like I told you earlier, like I need, ma'am, the extension since I have not completed the watching the videos. So, ma'am, I'll let you know shortly once we're done with this class. Is it okay with you, ma'am?
Sure.
Thank you.
So, but you know the whole structure of assignments, so I'll just
yeah, I know, ma'am. Yeah.
But sir, if it is okay, I will just give them a brief of like 2 minutes and then maybe we start the session. Hello, everyone. So great to have you all here today and welcome again. I would say, Mr. Badi, your session was extremely engaging last time and I also watched the recording, so we all enjoyed it and it was quite informative and, quite engaging. Before we start, I would like to discuss a very important aspect of the course, and I'm sure I hope by this time you're quite aware of our course structure, that is the assignments, a very important one. Assignments, so you all are aware, various kinds of assignments are there. The number one would be the MCQs. I hope that you're watching the videos and attempting all the MCQs assignments. Basically, they you help in revising the content given in the videos and reading materials. Now, the pre-class assignments, the assignments which you have to submit it before the live class well in advance. For the very simple reason, as in the live class, we will be taking up all your assignments. We will be discussing those and we will resolve all your queries and questions in the live class only. So what's important is the timely submission. Again, a very important aspect. It will give us time to evaluate the class. Okay. And then we have the major assignments, which are, again, the post-class assignments, more elaborate one, more research-based ones. And the one which I found most of you have not been able to submit, not been uploading, is the class participation note. Now, this is the only for the attendees. So whosoever is attending the class, so once you attend the class, make sure that you upload the class note, which includes at least a half-page summary of what you have discussed in the class. Okay. The weightage for the class participation is 20%. So I'm sure most of you would not like to miss those. So once you attend the class, just write down a half-page summary, which is given in the portal, and just upload it. And of course, you can ping me in case you have some questions or queries regarding that. And that's all from my side. I'll just hand it over to Badri sir for the music. And Miss Juhi is going to be, joining you at the end, and she will explain what's coming up next for the course.
Thank you so much, ma'am.
Thanks so much. And thank you, everyone. Thank you. All yours. And we can start the session now. Thank you.
Thanks. So, good evening. I'm sure you would be sitting here in the midst of 2 holidays that came. Friday was a holiday and again tomorrow is a holiday. But before we go into the session, I should congratulate you because you've turned up with your assignments. I think one of you had a problem, but otherwise it's fine that you have made sincere efforts in doing those assignments. I got 3 assignments. I think it was yesterday, I guess. I have gone through your assignments. Very good. Excellent effort. So what we'll do today is that we'll do 2 things. First is we'll take up from where we left in the last class. That is the first thing that we'll do. And the second thing that we'll do is we'll have a look at your assignments. Okay. So let me not take the names as such because I don't like to point out that this is the person who has written it and all that. But I would like to take up each of your assignments and whatever doubts, observations that you may have on those assignments, you can let me know. 1 or 2 clauses that were drafted were very, very good. So that sincerity is appreciated. And let's also attempt as a third point for today's class to draft one of those clauses, right? Okay. So if you recollect in the last class, we did discuss each of these 3, or I should say 4 problems, including 2 of the first assignment, right? So this was the risk matrix thing that I think that you had attempted this in the previous round of assignments, is it? Okay.
Yes,
So,
sir.
and then we discussed this. So what we'll do today is that firstly, I'll provide you an overview of what could be a possible risk matrix. We have done a substantial portion of this, but I think one of you did not attend the previous session, right? Okay, so what we'll do is rather than going into detail, we'll just park this maybe at the end. Maybe we'll keep it in the end. Last 10-15 minutes, we do a recap of what all we did, we'll deal with, right? Okay. So then straight away we'll go to the third assignment. Okay, we'll deal with the second assignment. That's fine. Okay, so what is asked is first is capital contribution and profit and loss, right? And second is indemnity in the LLP based on the scenario that is provided, and cessation and retirement of the existing partners and winding up of the LLP. Right? So these are the three tasks that have been asked of you. So in the last class, this is the scenario that is provided where A will be responsible for managing the day-to-day operations and B will be responsible for operations and management of the LLP. Right? And these are equal partners. So that's the thing. And in the last class, we discussed what capital contribution is. If you recollect, capital contribution is wealth in the form of money or any other asset that is owned by the person. And in the context of the current discussion, so that wealth is brought into the kitty of the LLP for its use. So, and we also had a look at what are the ingredients of a capital contribution clause typically are. One is that how will the initial capital be contributed? What is the percentage, the amount? Then what will be the further contributions, the ratio, then the procedure for further contributions and ratio, and then the withdrawal of contribution. So all these are part of your capital contribution clause. This is what we saw in the last class. And I found one of you had submitted this capital contribution clause. It was a crisp capital contribution clause that covered many things. I'll read out for your convenience. The partners agree to contribute an equal amount of capital to ABC LLP amounting to rupees 10 lakhs and further add to it as and when required. The capital contributions to partners shall be used for the operation and growth of the partnership. So this clause covers 4 or 5 items. First is what would be the initial capital be? That is 10 lakh rupees. And how would it be contributed by? So that is both the partners will contribute equally. That is 5 lakh each. That is the second item. Then third is what will be the scenario for further contributions. So for that it is stated that partners will further add to it as and when required. That is provided here. Then it says the part and how the capital contribution will be used. That is for the operation and growth of the partnership. Well and good. Now, what about withdrawal? Then what about further capital contribution? What is the ratio of further capital contribution? So these are some items that are probably missing here. So what can typically happen is that if it is a very simple LLP, then that's not a problem. LLP agreement, that's not a problem. You can draft a simple one, but you will always draft an LLP thinking that it will grow, right? In a few years, it will grow, and there is a possibility that some more partners could be included in the LLP, right? So, Acha, tell me one thing. You have all taken up, listen to the class on LLP now, detailed class on LLP.
Yes,
Am I right?
sir.
Yes, sir.
Yeah.
Okay, so what is the maximum number of partners that an LLP can have?
Like 2 designated partners.
Any idea? You can have a look at the ballot and tell me. It's not a quiz.
Actually, sir, in the class, we were told that it is maximum up to 20 partners, and a partnership can have. But recently, again, when I went through the notes, it is like there's no maximum limit upon the number of partners one can have. But according to Companies Act, one particular section, it says that less than 100. If that I'm not sorry, I'm not remembering that section, but
No, no,
it
no.
says that the amount has to be less than 100. I mean, if it is more than 100, then I think it has to be registered, or I mean, it automatically converts into a company. That was the gist of that section. That if the partners are more than 100, then it has to be incorporated as a company. So that is one we can say a limitation. Apart from that, in the LLP Act, there is no I think there is not a maximum limit as to how many partners can be there.
So if there is no maximum limit on the number of partners of an LLP, then chances are that the number of partners will be more. No? In the future, as the business grows, then possibly there will be 2 designated partners who will run the show, and there will be several other partners, right? That possibility is there.
Yes,
And
sir.
sometimes what happens is that after the death of one of the partner, the legal heirs may be included as partners. That possibility is also there. So the long and short of it is that you contemplate a scenario where there could be more than 2 partners in an LLP, right? So then therefore there'll always be further contribution. Now, if there is further contribution, what is the ratio of contribution, right? Then what will happen in case of what will be the ratio? Say there are 7 partners at that time. Then what will be their ratio of contribution? Okay, so all these questions arise. So what you could typically have is a clause like this, which says that like this particular clause which is there in front of you, the initial contribution will be so much rupees. That will be the first thing. And how will it be contributed? Like how it is there in this clause, it will be contributed equally. Okay. Or rather, you can say that it will be contributed in so and so percentage for so and so rupees. For example, the first partner will contribute 5 lakhs, is at 50%. The second partner will contribute at 5 lakhs, it is at 50%. Okay, then you can say, how will the further contribution be? Okay, then the question of ratio is there. So you can say that the further contributions, if required by the LLP, shall be brought by the partners at such ratio as may be determined with the consent of all partners from time to time. This is one possibility. Or you can say that it is with the consent of the majority of the partners from time to time. This could be another scenario. Or you could also say that the further contribution shall be in accordance with in the ratio of voting rights. For example, there are 5 partners, each having 20%. The further contribution will also be at 20% per partner. That possibility is also there, right? So, or the profit sharing percentage. Let's assume that the profit sharing percentage is say 25 for 4 partners and 0 for 1 partner. So then further capital also be contributed in that percentage. That possibility is there. So all these are possibilities that you must be aware of. You remember in the last class we had discussed about a checklist. No, what was it?
Sir, maintaining the checklist is to ensure that any element is not missed while drafting the agreement.
Absolutely. So what happens is that in your checklist, you make it as detailed as possible. Okay. See, in practice, let me tell you, you might be working as an in-house counsel. Okay. Suddenly you might be, or you might be working in a law firm or elsewhere. Suddenly you might be asked to draft an LLP agreement. Okay. So then you will not sit and think about all these things. No. So you should have ready-made checklists with you. And this is the stage when you can do it. So simultaneously while taking up this course, why don't you attempt a detailed checklist? Okay, so if you attempt a detailed checklist, then what will happen is you will not miss these things. Okay, like I told you in the last class, any agreement, whatever may be the agreement, addresses 2 things. One is, can you tell me? You recollect?
Pardon, sir?
What does an agreement address? What are the 2 things that any agreement addresses?
Future risks, future dispute risks, and how to address them.
Okay, so if you recollect in the last class, we said any agreement addresses 2 things. One is risks, okay. The other one is situations. You recollect?
Yes, sir.
Any agreement addresses risks and situations. So in addition to that, there are declaratory provisions. You recollect the last slide we had declaratory clauses, which will declare something. It will declare saying that this is the partner, he is having the registered office at so and so, so and so, so and so. But declaratory provisions may have substantive impact. That also we saw. You remember we saw a table. Okay, if you don't recollect, let me see if I can share that slide. Are you able to see my screen?
Yes, sir.
Okay, so first is this formal declaratory provisions. The first thing was any agreement addresses risks and situations. Then it will have formal declaratory provisions, right? Then in formal declaratory provisions, I gave you 2 or 3 examples, right? You recollect this slide?
Yes, sir.
Okay. In any case, see, agreements address risks and situations. Okay. And in addition, it may have declaratory. So you draft a checklist in such a way that it will contain these aspects. Correct?
Yes, sir.
Okay. Now let us come back to our session. Just a second. You're able to see my screen?
No, sir.
What about now?
Yeah.
Sorry. Okay. So then coming back to the this one, we were talking about the checklist, no? So your checklist will address declaratory provisions, then risks and situations, right? So these 3 are the main ingredients of any agreement, right? So accordingly, you draft your own checklist. Okay, if you draft a checklist, then during the course of your practice, you will come across a new clause. Then you will say, why can't we put this clause? Then you'll add that to your checklist. Like this, like that, keep developing your checklists. Okay, you will have a general checklist for any agreement. For whatever may be the agreement, there will be a general checklist. Okay, then you will have an agreement for services, performance of services. Then you will have one checklist for purchase or sale of goods. Then you will have a checklist for different kinds of entities. Say if you want to establish a company, then what are the things that you must do? Okay, then shareholders agreements checklist, then LLP agreements checklist, partnership agreements checklist. Like keep developing checklist. Then transfer of property. Typically, we have lease, licenses, sale of immovable property. So keep developing checklists, not only in respect of these major transactions. And again, one more thing is that non-disclosure agreements. These are also very, very important. Okay, whichever area you're practicing in, if you're in law, then you'll come across non-disclosure agreements or confidentiality. Right, so have checklist for all these things. Now coming back, so we saw the situation of further capital, right? Then further capital, how will further capital be contributed to? Then we saw 3 or 4 scenarios. Then comes contribution, not in terms of money. So like I told you, capital may not, it's a wealth. Okay, it may be in the form of money or it may be in the form of something else also. Like yesterday in the last class, somebody talked about furniture. No, that could also be a contribution. Then somebody talked about furniture. Yeah, then there could be intangible property. What is intangible property?
Intellectual property.
But what is intangible?
Something.
Intangible property. IP is an example of an intangible property. What is intangible property?
Basically,
It cannot be touched.
Yeah.
Yeah. So the tangible means something that can be physically seen or touched or felt. Intangible is something that cannot be physically seen or touched or felt, but is still there. So intellectual property rights are examples of intangible property. So a contribution may be in terms of intellectual property also. Like let us consider a scenario where an inventor has invented something and wants to put that to commercial use. So he is inviting an investor to invest. So the investor brings in money. The inventor has his invention. They both come together, form an LLP, and run it. And the LLP agreement says that the inventor will bring his IP and use it for the purpose of the LLP. Okay, is it capital?
Yes, sir. It can
Yeah,
be
it is
capital.
capital. It is capital. That's exactly what we are seeing right now. No, that capital can be in terms of money or intangible property, goods, whatever may be the case, right? Then additional contribution we saw, and there is something called dilution. Have you read your corporate law class? Something about dilution?
No, sir.
Okay, so I'll just put it in simple. Okay, there is a scenario where there are 50% partners. Okay, and let's say that they bring in another two new partners. Okay, who will also make equal contribution, and then their voting rights and interests in terms of four partners becomes 25%. Right, they have equal holding over the LLP, right? So a person who had 50% initially, his interest after bringing in new partners and bringing in new contribution of capital becomes 25%, right? So the reduction of interest in the LLP with certain structural changes in the LLP is called as dilution. Okay, so this dilution happened, and the LLP agreement might be structured in such a way that because of dilution, that partner might lose his rights in the partnership. For example, let's say that any decision is to be taken in the LLP by a simple majority. Okay, so initially that partner who was a person having 50% holding in the partnership, right, might be the person who will decide things, right? Along with the other person who will have 50%. Now, if his interest gets diluted to merely 25%, what happens to the majority? So the other three partners can come together and take things forward, isn't it? Am I right?
Yes.
Okay, so this is dilution, and these days what happens is that there are a lot of corporate agreements, especially startups and all, no, they have their own dilution or anti-dilution provisions that are there.
So sorry for the interruption. So can you come again with the concept of dilution? It's not that clear to me, sir.
Now let's say that let's consider a scenario where A and B are there in this very problem. Okay, in this very scenario where there are two partners, right? There are two partners, A and B, both are equal partners, right? Equal partners in the sense what they have 50% holding in the partnership, correct? Now, because of certain structural changes in the partnership and some further contributions from two partners who are inducted, okay, assume that this is the scenario, and their holding is now 25% each. There are A, B, C, and D who are equal partners now, right? If they're equal partners, then they have their 25% holding or interest in the partnership, right? So if the LLP agreement initially provided that decisions will be taken by majority consisting of at least 51%, correct? So at the initial stage, A and B could decide things together, and A cannot act unilaterally, B cannot act unilaterally because each one held 50%. Now with the induction of new partners and other structural changes, now each partner owns 25% interest in the partnership.
Okay.
Okay. Because A, B, C, D, so 100% divided by 4 is 25%.
25%.
Correct?
Yes, sir.
Okay. Now, A, C, and D can decide things on their own. Even if B does not agree to something, by simple majority, A, C, and D can take things forward. Correct?
Yes, sir.
Okay. So therefore, B's right or B's power in the partnership has diluted.
Yes.
Okay. So there are provisions in LLP, mainly they are used in startup companies, okay, called as anti-dilution provisions, which protects such dilution of interest.
Yes, sir.
Okay. Now let me come back. So those clauses can also be added Like if you have had a look at that sample where it talks about Ambani's being parties, those kinds of complicated arrangements could have anti-dilution provisions also. Okay, then of course we are talking about withdrawal, right? Withdrawal of contribution. So all
excuse me, sir.
Yeah.
So how will they be? I mean, what will be their language? I mean, all the if new partners are added in, and suppose share voting rights are diluted. So what will be the language of anti-dilution? I mean, will they say that even if we are new partners have been added, but still their voting will be considered at par to 50%? I mean, what language will be used in these?
See, that is one possibility. The other possibility is to say that decisions cannot be taken unilaterally by the partners, that all the partners have to agree upon something. That is possible. That is the second variant. The third variant is that you can say that each of the decisions of the partnership will be at least by 75% of the partners or 80% of the partners. That is possible. The fourth possibility is to divide the kinds of decision into two. One is normal decisions, and the other one is certain critical decisions. And for critical decisions, you have 100%, and for normal decision, you have 75% or 80%.
Okay, thank you, sir. So it's upon the partners how they want to.
Yeah. So therefore, that's why I'm saying the larger lesson that we learn out of it is that if the LLP agreement is going to expand, the LLP business is going to expand, and there's a possibility of bringing new partners all, you might as well draft an LLP agreement that covers that situation. You get it? Don't just be short-sighted. Look at the future. So this is a situation. The situation is that there might be possibility of new partners entering, and the risk with that situation is that your interest might get. Okay.
Yes. Okay,
then comes withdrawal of contribution. How will withdrawal of contribution be made? Then if there is a withdrawal of contribution, whether it will be in part or in full, and then if it is in part or full, then whether the LLP agreement has to be modified. So all these your capital contribution clause will deal with. Okay. Now let us have a look at the indemnity. You recollect in the last class itself we saw various kinds of indemnities. No, in fact I had precluded, I should say, a decision on showing you actual indemnity clauses by putting it in the first session itself. I should have parked that issue for the next session, but I had done. Yes.
With respect to withdrawal, I have a question, sir.
Yeah.
So, sir, suppose one partner has contributed, like you said, through furnitures and all, the capital. So, if he wants withdrawal, then he will be taking back those furnitures or what?
Yeah.
What?
Yes.
Okay. Or it can be done through like payment of cash. How?
That's possible. See, it all depends on the agreement between the parties. No, if the withdrawal of contribution clause talks about taking it on an as-is where-is basis, withdrawing.
Will there be any valuation, sir? Will there be any valuation of? Will there be any valuation of the contribution?
Of course, there will be valuation. Of course, there will be valuation. Any property.
That is done by whom, sir?
That
is done by whom, like CA or?
If it can be done by consensus, it can be done by consensus. But if there is no consensus, then appropriate dispute resolution mechanism can be invoked.
But who are the better people equipped for evaluation, sir? Is it CAs or any other?
It depends. Say if it is a machinery, what will you do? Then CAs may not be in a capacity. No, engineers will be in a capacity to value it, right?
Okay, sir.
Okay, so it all depends on the asset.
Okay, sir. Thank you.
Okay. And sir, building upon this question, so should ideally, I mean, the one should add this thing also in this capital contribution clause, that ideally the voting rights, they are co-terminus with the capital contribution of the partners. So in the capital contribution clause itself, one may mention that how the intangible property has to be valued. I mean, in order to know what will be that person's voting rights, first of all, his intangible property has to be converted into something tangible. That's
yes.
So in the capital contribution clause itself, one can mention that. So any intangible property, if a person is so and so is putting that this and this firm will calculate it and make it tangible, and according to that.
Yeah, so actually you will not usually put it as an open-ended manner. You will have your capital contribution clause in terms of money. The exceptional scenarios are where intellectual property, typically intellectual property LLPs, where you bring in a intellectual property and then that intellectual property is used. Okay, so that is where this problem will arise. Generally, if you look at most of the LLP agreements, they will have capital contribution in terms of money terms, right? But like you said, when it is asset other than money, then the concept of valuation, right?
Sir.
So the concept of valuation comes not only at the time of initial contribution or further contribution, it also comes at the time of withdrawal. So in these three scenarios, it comes. So let's say, again, take a situation of A and B. A is the person who's owning that intellectual property. He brings in, B finances. Then the LLP would like to have further financing because they want to expand their business. So they induct new partners, C and D. So when C and D comes, then each of B, C, and D contributes capital. So the question arises: should A contribute further capital or in terms of money, right? So therefore, the question of assets and contribution by the person who has contributed the assets, okay, comes not only at the initial stage, it comes at totally three stages: initial stage, further contribution, and withdrawal of funds.
Okay, sir. So one can also make it a separate clause if one wants to. I mean,
yes,
that's
yes,
upon part.
But I'm telling this scenario just to make you aware that that possibility is there. But predominantly, at least to the extent I understand, it is capital contribution is in terms of money.
Okay. Thank you, sir.
Okay, so coming back to indemnity, I explained to you about 5 types of indemnity. No? So indemnity, one was indemnity to the LLP for fraud by the partner, then indemnity to LLP and other partners for separate debts, then indemnification that is done in the course of business. Then we saw general indemnification, which consists of 2 parts. So general indemnification is the LLP's duty to indemnify its partners and officers for all liability. The exception being gross negligence and willful misconduct. Okay, so there are 5 types of, the general indemnification has 2 elements. So if you include those 2 elements, there are 5 types. Otherwise, you can call it 4 types. That's up to you. But then these many types of indemnities are available in an LLP agreement. Okay, so one of you has drafted this. This is well and good. It says, with the exception of cases of negligence or malicious misconduct, the LLP shall indemnify each partner as well as each of their agents, employees, and representatives against any claims, losses, damages, or expenses incurred as a result of their activity on LLP's behalf. Except in circumstances of fraud, extreme negligence, or willful misconduct, each partner's responsibility is restricted to the amount of separate capital. So this has broadly 3 elements. Okay, first is an indemnification. Okay, indemnification covers not only the partners, it also covers agents, employees, and representatives. So this is the second element. Third element is an exception, that is fraud, extreme negligence, and willful. So 3, I can call it 3 kinds of indemnification are covered here. Okay, I have a few comments on this particular clause. Okay, the first comment is that the concepts of negligence, malicious misconduct, extreme negligence, fraud, willful misconduct. So totally 5 concepts have been used here. Okay, I'll repeat: negligence, then negligence is used here, then extreme negligence is used here, then fraud is used, malicious misconduct, then willful misconduct. Okay, so can somebody tell me what is the meaning of each of these?
Yes, sir. So I had drafted this. Like in a contract class, when we're covering indemnity clauses, so we read about different case laws. So in each of the case laws, different situations were there, like one of negligence. So negligence was not very voluntary. So in that case, and in the case of malicious misconduct, so it has been done deliberately. And then fraud, so purporting to be someone else or something else, or although you know that you are not that. And extreme negligence is in the case of that, yes, there was a criteria for caution, but you did not maintain even that to the extent of going extremely negligent. And willful misconduct is obviously a deliberate attempt on executing actions which could have been duly performed.
Okay. So, look, let me tell you something. That you use 5 different terms, no? Then see, this agreement is going to be interpreted by 2 classes of people. One is the partners themselves who are going to implement this, and the other is the courts or arbitral tribunals, as the case. They are going to be confused if you use so many concepts which refer to basically it's basically negligence and misconduct.
Yes.
Okay, negligence in literal terms is an apathy in doing something which results in some loss, and misconduct is something that is it's a bad conduct. Okay, in simple, right? So then, what is then the question will come: what is the difference between willful misconduct and malicious misconduct? Okay, so malicious misconduct, is it that it is done with malice, but willful misconduct is not done with malice?
Yes, so malicious misconduct obviously involves bad intentions, and willful misconduct would be not necessarily involving, because if the intention is taken into consideration, then that involves malicious.
See, you are not.
But yes, so this would create confusion.
So you see, you're not involved in a criminal law class, no, or a criminal law issue to look deeply into motives, intent, and all that. So the standard is that you exempt partners or anybody's conduct from indemnification in case of negligence or misconduct. This is a typically used standard. Or if you want to go one step above, then it is gross negligence or willful misconduct.
Yes.
Okay, misconduct done with malice will come under willful misconduct. Okay, these are the 2 typical industry standards that are used. You look at any agreement, you'll have, any agreement in the sense, any agreement which is crafted in a proper manner, you will have negligence or misconduct, which is at a lower threshold. Okay, or gross negligence or willful misconduct, which is at a higher threshold.
So one thing that the question was not like, yes, it did mention that which of the parties are involved in which kind of actions. But then if the question itself becomes very specific, then the drafting will become more specific. Or you are saying that, yes, the question be whatever be, the drafting has to be very specific, because I was thinking very generally, very broadly. So I involved almost everything that I
not a problem. Not a problem. Only thing is that, see, let us just take a case of fraud. Okay, so fraud is, that is in simple terms, knowingly saying something when you know that it is not true. Yes. Or omitting to say the truth when you have an obligation to say the truth.
Yes.
Okay, so therefore these are 2 classes of fraud. So when you are explaining or dealing with fraud, you will not detail each and every type of fraud, no?
Yes, sir. Sure.
So that's the thing. So you have a genus, then you use the genus. There is no need to specify the genus and species also, because species is a part of that genus, right? So that is why I'm saying the when you say negligence or misconduct, that is a lower threshold. Okay, misconduct will cover malicious misconduct, fraudulent misconduct, willful misconduct, and all that. Okay, so therefore, if you want a lower threshold, you can use merely misconduct. But if you want a still higher threshold, which is generally the practice, that is gross negligence or willful misconduct. If gross negligence or willful misconduct is there, then the actions of the partner or the officers won't be indemnified by the LLP. Okay. Now, let us come to that clause which we read last class. I'll read it once again. Every partner shall indemnify the LLP and the other existing partners for any loss caused by his fraud in the conduct of the business of the LLP. This is one example. Okay, this doesn't even cover misconduct. It covers only fraud. It does not even cover negligence. Okay, this is a clause that is intended to protect partners basically, okay, from fraudulent actions from other partners. Okay, I'll read it once again. Every partner, so a partner has an indemnification obligation to the LLP and the other partners for loss that is caused because of his fraudulent actions. Okay. Then let us skip to the third one, because the second one is a special case. The third one, what does it say? The LLP shall indemnify each partner in respect of payments made and personal liabilities incurred by him in the ordinary and proper course of proper conduct of the business. So he does something in the proper conduct of the business. Say he incurs certain expenditure. You remember the example I told you about potatoes and keeping it in refrigerator in the last class? So in the ordinary course of business, he incurs certain amounts. So that is to be indemnified by the LLP. Okay, and it also says that either that the payments or liabilities should be incurred in the ordinary and proper conduct of the business, or in or about anything that is necessary for the preservation of business or property. Coincidentally, day before yesterday, I forgot to tell this example. What had happened is that my colleague and I were discussing, and then he was saying that there was a situation where an authorization letter was given to a subordinate by the owner of a concern. So what that subordinate did is he went and bribed a police officer. And the police officer not only prosecuted the subordinate but also the owner. Then the owner said, "Look, why are you prosecuting me? This is the action of the subordinate." Then the police said, "Look, the subordinate is not only acting on his behalf, he's acting on behalf of you." Okay. Then the owner countered by saying that, "Look, I have given him that authority to act on behalf of the concern, that is the concern whose owner he was, for all lawful actions and not for illegal actions." Right? So that is why this indemnification will say that in the ordinary and proper, that is very important, proper conduct of the business of the LLP, or in or about anything necessary for the preservation of business or property. Okay, so this is very important. Then let's come to the general indemnification clause we were talking. If you look at this, this is blah blah blah. Okay, that we have already seen. Look at this, except for gross negligence or willful misconduct of the partner or officer seeking indemnification. Okay, so this is at a higher threshold. So if there is gross negligence or willful misconduct, then the LLP will not indemnify and defend the partners or officers. But if there is no gross negligence or willful misconduct, then that indemnification will be available. Okay, so here you need not say gross negligence that amounts to substantial loss, gross negligence that amounts to minimal loss, or willful misconduct that is with fraudulent intention, or willful misconduct with malicious intention, or willful misconduct that is intended to hurt the LLP, willful misconduct that is intended to hurt a third party. So you need not specify all these things. All these come under willful misconduct. Okay. Now let us come to the special case. Indemnity to LLP and partners for separate debt. So it says that every partner shall indemnify the other partners and the LLP, name of the LLP, assets against personal debts and engagements, and against all proceedings, costs, claims, and demands interested thereof. So you are a popular LLP in a particular area. Okay, one of the partners owes you some money. Okay, so what you do? You say that, "Look, I know that person owns me in his individual capacity, but still I'll cause as much trouble as possible, and I'll also include all the other partners of the LLP and as well as that LLP, just to shame them and embarrass that partner. And I include all the partners in the LLP. In such case, the partner who owes that money to me will have to indemnify the LLP and the other partners, okay, for any expenses that may be incurred in defending this. So you look at this, you find so many kinds of indemnities that are there, right? It is not just one type of indemnity clause. It is a bundle of indemnity clauses, I should say. So one type of indemnity by the LLP to its partners and officers, another type of indemnity that is by each partner, right? Then we come to the question of indemnities done in the usual course of business. Then comes indemnities in case of situations where there is gross negligence or willful misconduct. So many ingredients are there. So therefore, my point is, when you make the checklist, mention all these things in your checklist. See, when you have a checklist, all you look at when we maybe draft the meetings clause. If you have all your ingredients, it is just a question of framing English sentences. Okay, see, people might confuse you by saying that, look, when you're drafting an agreement, you'll have to use special words, special jargon and all that. Okay, if you're familiar with the jargon, that is fine. Otherwise, simple English sentences which clearly convey the meaning will do. Okay, in India, substantial portion of agreements are entered into, executed. I'm not talking about just small stakes. High stakes agreements are entered into without legal vetting. Okay, if you're a practitioner, you'll know that so many agreements are done without legal vetting. So Indian courts and tribunals are not new to construing such agreements. Okay, so even if you are not aware of the lingo or jargon of drafting contracts, that is fine. Use simple English, but you should not miss the ingredients. That is the key thing. Okay. In fact, you can even have. Let me just give you an example. That why don't you consider there is a checkbox. Let's take this checkbox. Just a box, okay? Just a table that says arbitration, Mumbai, right? Arbitrators 3. Whether this provision, say this box is there in your contract, whether this agreement is enforceable. Let me tell again, there is an agreement, say LLP agreement. Okay, the last clause is just a table. Table has 2 columns. The first column says arbitration. Against it, it is said Mumbai. Next row has arbitrators 3. That's all. Whether this is an arbitration clause.
Unless in the clauses in the agreement itself, it mentions that yes, in case of dispute resolution, this is the method, and then that table is referred in context to that clause.
No. It is just let's say clause 36 and the table. That's it.
No, sir. It doesn't make sense.
Then why is it there in the first place? Then why should it be there? See, what is an arbitration clause? Okay, that is a clear and unequivocal intent to arbitrate has to be mentioned. Okay, there is a table which says arbitration. Okay, and it also provides the place of arbitration, Mumbai, and it says number of arbitrators, and it says 3 arbitrators are going to be there. So my point is, how does it matter if it is in the form of sentence or if it is in the form of a table? To me, it is still a clear arbitration clause. Okay, you will find several such agreements in the course of your practice, drafted especially by engineers, which are having these tables or checkboxes. There'll be a checkbox type of clause will be there. Arbitration, there will be a tick mark next to it, and arbitrators 1, 3, 5. So 3 and 5 will be struck down. Only 1 will be there. See, Mumbai, Delhi, Calcutta, Chennai, all the other 3 will be struck down. Only Mumbai will be there. I'm just giving an example. So these type of agreements are also possible. That is the larger point that I'm driving at. It need not be in terms of legal sentences having LLP shall indemnify, demand, defend, protect, hold harmless its partners and officers against so and so, so and so. Okay. It can be very simple also. That is the point that I'm driving at. So the larger issue is that you have a checklist, you have detailed ingredients, then it is matter of writing English. Clear English, of course. I'm not saying no, but English. Okay, that is the reason why I keep stressing. You have a checklist, you have your ingredients. Okay, then it will be easy. We'll have a look at it. Okay, we'll have a live drafting thing. We'll draft one of the clauses. Again, for cessation and retirement, this clause that is provided here is a list of ingredients. You can include it in your checklist. We saw all this. And now let's come to assignment 3. Let's draft the live. Will you give me a 5-minute break? I think as per my watch, it is 6:58. Right? 7:3 or 7:5. Let us reassemble. And what we'll do there is that we'll draft based on this facts a meeting clause. Okay, before drafting a meeting clause, we'll have a look at this sample that one of you has done, and then we'll just draft this meeting clause. Okay. Okay, so we'll reassemble at 7:05. That is about 7 minutes from now. Okay.
Okay, sir. Sure.
Yeah, I think I got logged off. Let me just contact ma'am so that I can get the screen share done. Yeah, so till my screen share is activated, let me ask a question to you. Say, consider these two practitioners. Okay, let's call one practitioner Ramesh. Okay, Ramesh is having 20 years experience in contract drafting. He has drafted, say, about 50 LLP agreements. Okay, then let's say Nandu. Nandu is a new practitioner. She joins Ramesh's law firm. Now, she knows well the theoretical aspects of LLP agreement. She's read the LLP rules and stuff like that. She knows everything in theory. Okay, so but she's not drafted an LLP agreement. How should she start learning how to draft?
So, may I?
Yeah, go ahead.
Yeah, even if she has done it theoretically, like you told how important is it to maintain a checklist. So she can ensure that checklist, and accordingly she can discuss with the one who's experienced, and while ensuring that with drafting consistently, I think the major aspects will be dealt. And you also said that if in accordance with like maintaining the checklist, it is also essential to exhaustively use all the elements that are necessary and in an objective sense, so that can be done.
Okay, good. So see, what are Nandu's sources? Now, Nandu's sources is, first of all, her learning itself. That is number one. That aside, then she has her senior or mentor, Ramesh, who has drafted 50 LLP agreements in his life, right? Then, possibly, and more importantly, Ramesh has those LLPs that he has drafted, okay, with him. So Nandu can study those 50 sample agreements, 50 LLPs, right? Then she can, as you had said, she can use the checklist, prepare the checklist, update that checklist, and see. Let's say that voting rights clause might have different variants, no? So all those variants can be inbuilt in the checklist. Okay, so we all are. I mean, not only you. I am also like Nandu. Okay, so we have access to checklists. We have access to samples, and we have access to our seniors, whoever that may be. Okay, so using your seniors and those samples, we build the checklists and empower ourselves. Okay, in drafting. Got it? Okay, now let's come to assignment 3, where we'll be doing two things. We'll look at one of the sample clauses on meetings, then other one is we'll draft an assignment clause. So one of the samples here says, I'll read it out. The meetings of the LLP shall be held in accordance with the provisions of this LLP agreement. Okay, at least once every quarter at a mutually agreed time in the registered office of the LLP and in compliance with the applicable rules and regulations. Each partner, namely A and B, shall have one vote in all matters to be decided by the LLP, except reserved matters where B shall have a veto right as specified in the LLP agreement. Okay. Now, there are very good things about this clause and a few things that you can avoid. Okay, the very good things about this clause that this clause is short, but it encompasses so many aspects. Okay, so first of all, it says that the regularity of the meetings once in every quarter. Then at what time? It will be at a time agreed between the parties. Then the venue, it talks about the venue. Then it talks about how the voting will be there, and it talks about who will have the veto right. Okay, and it talks also about reserve matters. So these are the good things about this clause. It's very crisp, but contains so many things. There is something that could be avoided is that the agreement is circular in certain ways. Take this, where B shall have a veto right as specified in the LLP agreement. Okay, so this would mean that there should be some other clause which talks about the veto right. Then this makes sense. If there is no such clause which provides for veto right, then this clause is circular in its reference because it refers to the veto right as specified in the LLP agreement. Okay, then let's take another thing. See, these are not like real blunders or faults. Okay, because look, some few weeks back, I was doing a online lecture. Then for that I was preparing. Then I had looked at some concept called as pathological arbitration clauses. Okay, pathological arbitration clauses are basically defective arbitration clauses. They suffer from defect because of which parties are not able to refer the matter to arbitration. Okay, one of the defective arbitral clauses was in a case between Pricol and Johnson. Okay, Pricol is an Indian company which is having whose customers is worldwide. Okay, Indian companies' customers are global, and Johnson is a well-known multinational company. Okay, despite the strength and the resources of these two companies, they still agreed upon a defective arbitration clause. See, if one party does a mistake, then that's fine. Both the parties who are very sophisticated parties did that mistake of drafting a defective clause. The lesson that we learn is that drafting is not something that happens only to novices. It happens to very seasoned and sophisticated players also. Okay, so what really will help you is to have a checklist and to have due diligence and read the clause 3 or 4 times. Okay, so the point is that these are not blunders, but these are small mistakes that you could avoid, which one of the parties will take advantage of in a dispute. Okay, so but unfortunately, see, the litigating lawyers' duty or the litigating lawyers' innovation lies in finding a defect in the agreement, and the drafting lawyers' innovation or I should say duty lies in ensuring that the litigating lawyer does not find any mistakes or defects. Okay, so in that sense, a transactional lawyer and a litigating lawyer are at opposite ends. Okay, so that thing is very interesting. Now we're coming back. Now let us look at the meetings clause. I think we discussed. There are a few more things here. So does this clause specify who will convene the meetings? Number one. Number two, what about notice of meetings? Then decisions, yes, to an extent it deals with decisions, so that is not a problem. Okay, then clauses and subclauses. Okay, what is this subclauses and subclauses is that, look, when you are drafting a lengthy clause, no, it is better to divide it into subclauses so that it is readable, number one. Number two, clearer clauses will actually ensure agreement by the other side. If your clauses are clear and crisp, no, other parties will easily understand it and will say okay. Okay, if you draft a very complicated clause, the other party might not understand, and that might be a reason for that party not agreeing. That is the second problem with drafting lengthy clauses. The third problem is that there is something called as a contra preferentum rule. What is it? Contra preferentum.
Yes, under this rule, generally it is meant that whoever has drafted the clause and that there is defect in that clause, it will be taken against the person who has drafted the clause.
Absolutely. So where there is a ambiguity in a clause, then that ambiguity will be construed against the drafter of it. That is contra preferential rule. Okay. Now look at this, where B shall have a veto right as specified in the LLP agreement. Now let's say that B has drafted this particular agreement. Okay, you as his counsel, B's counsel has drafted this agreement. Now there are two ways of construing this in the absence of another clause on veto right. One is to say that B shall have a veto right. The other one is B shall have a veto right if it is specified in the LLP agreement. Okay, so I'm reading if here. So then this clause presents an ambiguity, no? So therefore, it is possible that courts might construe this against B because B being the drafter and due to application of the contract. Okay, so these are things that we need to be careful about. Now, you remember last class we had these ingredients, and I've just provided here an explanation to this. Okay, these are like lengthy meetings clause containing many of the ingredients here. Okay, now what we'll do is let me draft this for you. Okay, I'll just stop screen sharing. I'll open another Word file and then I'll screen share there. Able to see the screen?
Yes, sir.
Yes, sir.
Yeah. Okay. So let us straight away go with drafting this. So number of meetings within intervals. So the explanation is that meetings are to be conducted periodically. How will you draft this? You dictate to me. Let me just put it. Then you can say. Okay. Now tell me. You have a meetings clause like this. Okay. It's not a full meetings clause. Let's assume that this is just a sub clause. Okay. Now tell me if this clause is enforceable or not.
Yes, sir, it is enforceable.
Okay. Now let me put it this way. This clause is not drafted in legal language. Okay. But it is drafted in simple English only.
Yes, sir.
Right? Would this clause be enforceable?
Yes, sir.
Let me put it the other way. Will the courts stop or refuse to enforce this clause because it is in simple English?
No, sir.
No, right? So you have an ingredient and you have an explanation to it. Okay, so in your checklist you'll have this explanation also, or samples or types also. With that you can draft a simple clause. Then let's go to the other one. Who will be the convener of the meeting? Let's say that there is a managing partner. The managing partner shall convene the okay. Who is the convener of the meeting? Basically, he is the person who's the host for the purpose of the meeting. He calls for the meeting, then he gives the notice for the meeting, then he records the minutes. Basically, it's like the glorified secretary. Okay. This clause can also be that the designated partners shall together convene the meetings. Okay. Then there will also be a clause which will say that in addition, okay, this is just a sample I provided. In addition, or where partners holding 20% meeting interest or voting rights or whatever you call it in the LLP can or to use will be entitled to call upon the MD. I'm just using the short form to save time. Managing partner to convene meetings, in which case the managing partner shall convene the meeting. Okay. So this covers two situations. First is where the managing partner convenes the meeting, or where partners who hold 20%. This has a different meaning. So two or more partners holding 20%, holding at least 20%. They can also convene meeting. Assume that there are 10 partners. So one of the partner feels who's having 20%, or 2 or 5 of the partners who are having 10% each feel that, look, there is some issue that urgently needs to be resolved through a discussion with the partners. So they can also call up. Okay. Now, then see here it says managing partner will convene the meetings. And if partners holding at least 20% want to call for a meeting, they will call upon the managing partner to convene the meeting. Okay, and the managing partner shall necessarily convene the meeting in that situation. You get it? Okay, now let's come. This one noting over here. The managing partner shall provide the notice of the meeting along with the date, time, and venue and agenda at least prior to 14 days from the date of the meeting. Okay, date of the proposed meeting or meeting. Okay. Supposing urgent decisions are to be taken merely because 14 days notice is to be given, that should not prohibit the people from taking urgent decisions. So you have a clause in case of urgency affecting the LLP business of LLP, or in case of legal, the okay. Anything wrong? Any comment? You please interrupt me. And by the way, I may take about 10 to 15 minutes extra. Is it okay for you all?
Yes, sir.
Any problems? If
No,
you have
sir.
problems, I'll quicken it. That's the only thing.
Not at all,
No,
sir.
sir.
Okay, great. Okay, then now one more thing. Let me see if I've added it.
So one
Okay.
more thing maybe can be added. I mean, I have a question that in this notice and agenda, agenda clause, that what will be, how will it will be deemed that that notice has been served to the
That
partners?
is exactly what I'm coming at. Okay, the notice shall be sent by registered post or electronically to the address or email address ordinarily used by each. You can have any variant. You can say that, however, in case of urgent meetings, it is sufficient to send the notice by email. Okay. Then we go place of the meeting. Meeting shall be held at the registered office of the LLP. However, in case a partner is unable to attend the meeting physically, meetings can be attended through video conferencing as well. For this purpose, the managing partner shall post the paste. Okay, and send the link to where we see along with the repository. Okay, right. Now quorum. What is quorum, by the way?
So the composition of the constitution, number of one
the
particular
minimum number of people
Minimum.
required to constitute a valid meeting. Okay, this can be anything. Say there are two designated partners. The quorum or the shall consist of at least. I'm sorry, my power got cut. Are you able to hear me?
Yes, sir.
Okay, now let me come back to the clause that I was drafting. Okay, you're able to see the screen now?
Yes, sir.
Okay, at least, say if it is like out of 10 partners, at least 8 partners. 8 out of 10 partners. With both the designated partners being present. Okay, there is something called designated partners, no, in partnership, who run the day-to-day affairs and all that. In LLP, unlike partnership where designated partners are not there. So designated partners have some importance. So that's why I put it that way. You can have it in whatever way you want. Okay. So now voting, decisions shall be taken during meetings on agenda items on a consensual basis. If there is no consensus, decisions shall be deemed to have been taken if approved by a majority of more than 75% of the partners who are present and are voting. Okay, this can be any variant of approved by partners having at least 75% voting rights. That variant is also possible. I've just put in a variant so that I can explain it to you. Okay, then another issue is proxy. Proxy is appropriately placed here, not here. Okay, here, what is proxy?
The main partners sending other person to
so
meetings.
instead of you are represented by another person. So here you say that if a partner is unable to be present, he or she may authorize a proxy to be present on his behalf. Then I'm not writing in detail, then due and proper authorization. Okay, that should be there. That should be submitted. Okay, then only proxy will be considered. Right? You can also add a variant to this. Yeah, go ahead.
So in case of online meeting, if there is online meeting, then also how, I mean, we may add that how due and proper authorization will be shown in case of video conferencing of a proxy.
Yeah, that's also possible. Yes. That's true. How will he sign and all that is all there, but meetings can be recorded. Gone are the days when those cannot be done. These days meetings can be recorded. Right? So consent can be shown there also. That's not an issue. These days documents can also be shared. No, sharing of documents is also possible. So that's okay. I don't think in the current technological scenario it's a problem, but nevertheless it's a valid point that the issue of how to show consent is there, which is exactly where we are coming now. Decisions, how the decisions are to be taken. Here we have said that voting is there. Now, how will the consent be expressed? So can say that the decisions of the partners are to be recorded on agenda items by signature or by electronic signature. Okay. Then here, no decisions. Here you can talk about reserved matters. Can I say that for the reserved matters, full consensus is required and all that. Okay. Then, if there is a deadlock, the chairman or the managing partner may have the casting vote. Okay. Then resolutions. Resolutions are to be kept in original in the registered office. See, electronic signature is possible. So the first consent will be electronically registered. Then if the partners are not able to assemble in the registered office, they can come later and then sign on that. Till then, the electronic signatures will be valid. Okay, those kinds of things also you can have. Okay, then all these things will come here. Then ultimately, what will have the duly signed resolution shall be circulated by registered post and by email to all the other partners within 10 days from the date of the meeting. Okay, look at this meetings clause. You notice the small meetings clause and look at this meetings clause. In fact, I have not even put 50% of the items. See how many subclauses are there. Right? So many aspects are there. Now, you see, even if you are a seasoned practitioner, no, you will not be expected to remember all these things. No. Right? You'll not be expected to remember all these things. Of course, you're a practitioner, then things will come automatically, it will come as a flow, but even then you might forget something. So that is why having checklists will be of great importance to you. Okay, look, GH, it keeps going, GHIJK. So at least 10 to 12 subclasses are there in a small clause called meetings. Right? So what happens is in practice, see, if you are not able to think about what will be the key scenario, just think about a meeting. Say you are the managing partner, you are convening a meeting. What are all the issues and problems that could arise? Okay, till circulation of the minutes. So all these things you visualize, and then you draft your ingredient checklist. Okay, that will be a cool checklist that we will have. Okay. So we have drafted this.
Sir.
Yes, go ahead.
I had one question. When can we say that while drafting a particular clause is drafted and that we don't need to tinker more with it? I was recently drafting something and उसमें ये हुआ कि despite giving it to them, वो लगा कि something was amiss या something was a little too much. So where do we get that equilibrium?
That equilibrium comes based on something that we discussed in the last class. It comes on actually two things. Okay, first is what is the stakes involved in the agreement and how complicated you want it to be. Okay, this is one thing. And the second thing is the level of trust between the parties. Say if you think that the partners, trust is to an extent okay, and based on consensus they'll resolve some issues, and if the stakes involved is not going to be much, say let's just say this, it is an LLP in regard to selling of say eggs or bread and eggs, the business of selling of bread and eggs, for that he's conducted an LLP. You don't want a 100-page LLP, correct?
Yes, sir.
Yeah, because the stakes are also not much, and you will not expect the parties to go through each and every clause and subclause of the agreement, no, to decide the relationship. Most of it will be consent based, right? Whereas if say that you are bringing in a capital contribution of about say 100 crores, right? And if 7 or 8 partners are involved, and 3 or 4 of those partners are companies. Okay, then that is going to be a sophisticated agreement for which you might require some amount of sophistication in the agreement.
Understood, sir.
Okay, and just to add to it, one of the things that I'm my interest of research is incomplete contracts. Okay, see in draft, I think that is one of the points that was discussed in the EBC's contract drafting class also. If you go and search in your EBC website on drafting contracts, you will notice this particular subtopic being there. Can you ever draft complete contracts? Okay, the answer is yes and no. Yes, if you have all the time in the world to sit and draft a complete contract. You noticed that this small meetings provision had so many subclauses. So you have all the time in the world, and the more important thing is if you want to negotiate all these clauses with your opponent or opposite party, then you can. But even then you will miss out something. Let me give you the example of LIBOR. Do you know what LIBOR is?
No, sir.
London Interbank Offered Rate. Okay, this is the rate of interest of loans, short-term loans that are given among the banks in London. Okay, it may be 24 hours, it may be 1 month, 3 months, 6 months. Okay, that is the duration of the loan. Okay, so there is an organization called I think ICE that used to publish these interest rates. Okay, so right from 1920s, if I'm not wrong. Okay, at least from early part of the last century. So in various long-term agreements, spanning 25 years, 30 years and all, this LIBOR was the interest rate. Okay, so all the interest rates will be indexed to LIBOR. Okay, let's assume that there is a clause like this. In case one of the parties fails to make the payment, then they shall make the payment at an interest rate of LIBOR, the current LIBOR for 3 months loans or 6 months loans. So that is how that clause used to be. Okay, I work in the oil and gas industry where almost all production sharing contracts, these are contracts used for that is producing oil and gas. Okay, so almost all the production sharing contracts in the world have their interest rate as LIBOR. Suddenly in 2020, what happened? This IC, that is the organization which publishes LIBOR, decided to stop publishing LIBOR from a near future. That issue is still going on, but most likely it will be all the interest rates will be stopped published by June 2023. Okay, so this is something that was never foreseen by the drafters, that LIBOR will stop publishing. You have so many contracts in India, Indian production sharing contracts, that will go on till 2040 or 2045, 25-year contracts, those are, which index it to LIBOR. But LIBOR is going to stop in 2023. Okay, so the larger point is that I'm making is that you cannot foresee each and every situation or contingency. COVID, take the case of COVID. It's a very, very common example. Who thought to add COVID-19 to their force majeure clause or act of God clause? Nobody thought. So there were huge disputes in 2020 as to whether COVID-19 amounted to act of God or force majeure. Okay, the landmark and important decision is, I think, Halliburton versus Vedanta. It's a 2020 decision by Justice Pratibha Singh. Okay, Google Halliburton versus Vedanta. You should do Vedanta versus Halliburton or Halliburton versus Vedanta. Either of it. Okay, but 2020 Justice Pratibha Singh's judgment. Okay, that was the first prominent decision on COVID-19 and force majeure. Okay. So who thought COVID-19 will come and the entire contracting and ambiguities in the contract came up? Nobody expected it, no? So therefore, the larger point that I'm driving at is that although you may have the time and energy and effort to draft lengthy agreements, still you may not be able to foresee all situations. Okay, so that takes us to one last item that we were talking about, preemption. Right? So there are three partners. One of the partner wants to move out of the business of the partnership. So what is a simple preemptive right clause that you can have? Right? This is the clause here. I'll read it out for your convenience. In case any of the partners of so-and-so LLP desires to transfer or assign his interest in the LLP, he has to offer the same to the remaining partners by giving a 15-day notice. So this clause contemplates that if one of the partners wants to sell his interest, then he'll say that, look, I wish to assign or transfer my interest to somebody. If you want, you can take it. Okay. If within 15 days the other partners don't communicate to him, then he can transfer it to a third party. Okay. And once the transfer takes place, then within 30 days, the date of execution of the agreement, etc., shall be given to the existing partners. So this is a simple preemptive right. There can be further complications to it. Okay, let's say that the clause provides like this: in case a partner desires to assign or transfer his rights to a third party, then that partner shall negotiate the terms of the assignment or the transfer and put forth the very same terms to the existing partners. In case the existing partners do not wish to take up the interest at that price and on the basis of those terms and conditions which are reasonable, then consequences will follow. So if they agree, then they will buy it. If they don't agree, then he can sell it to the third parties at the same price and terms and conditions. Okay, this is another variant. So this is like a right of first refusal. Okay, so like this, so many other variants are also there as to selling of interest and restrictions on all. So that ends our today's session. If you have any questions, you can ask. Otherwise, feel free to leave. You can write to me also. I've given my email ID. Again, don't worry about asking. See, only people who ask will be able to get things. So if you have doubts or something, you can write to me at badrinath@abcpublishing.in or law@gmail.com. You note it and feel free to write whenever you want. Okay? Okay, that ends our session. Take care. All the best. Remember, checklist is the key. Nobody is going to tell you that everybody will tell you like you start drafting agreement, start practicing to draft. Practicing comes later. First, understand the structure of any agreement. Then understand what are the building blocks of that agreement. That building blocks will be forever with you through a checklist. Okay? Bye-bye. Take care.
Thank you, sir.
Thanks a lot, sir. Thank you.
Thank you, sir. Thank you, sir, for the wonderful session. Okay, students, so the next class module that we are starting is on incorporation and conversion. So in this module, you are going to learn how different entities are going to be incorporated and how one entity can be converted into another and what are going to be its effects. Okay. So go through the module, go through the self-paced course. There are assignments as well. Please complete the assignments. So there is going to be a live class on 20th May. Please attend that. And before you attend the live class, please do submit your assignments because as you can see, all your live classes are based on your assignments and how much you have learned in the videos. And, you have to go through the videos to be aware about the discussion, to fully more participate in the discussion in the class. Okay? Okay, guys. I am ending the class for today. Yeah?
Thank you, ma'am.
Okay, ma'am. Thank you.
Thank you.